Tonight we begin with a decision, a unanimous ruling from the highest court in the land that legal scholars had feared, debated, and in some corners quietly predicted. A decision that unfolded not over months of back-and-forth legislation, but in a single ruling. A single ruling that redefined the rights of every gun owner in America. A single ruling that changed what law enforcement can and cannot do during a traffic stop. A single ruling that drew a new line between constitutional protection and criminal exposure permanently. What the Supreme Court did today crossed a boundary that gun control advocates had hoped would hold, and when that line broke, the legal landscape did not hesitate to shift. It shifted with clarity, with unanimity, and with the full weight of 9 justices behind it. For years now, there had been signals, not from official press releases, not from formal legislative channels, just signals, that the Supreme Court was preparing something seismic in the arena of Second Amendment law. The court has been active, yes, but it has been methodical in its activity. Its moves have followed a certain rhythm, a pattern, almost a deliberate cadence. But what set off alarm bells in legal communities and policy circles this term was that the usual procedural noise went silent. Constitutional attorneys who monitor Second Amendment dockets know the indicators: the clustering of related cert petitions, the sudden scheduling of oral arguments on long-dormant cases, the unusual alignment of ideologically diverse justices during questioning, the sudden absence of public commentary from sitting justices. All of that went quiet. And whenever the Supreme Court goes quiet before a major term decision, it means something is about to get very loud. Legal analysts had been watching this particular case, one involving the rights of licensed firearm owners to transport weapons in their vehicles, for over 2 years. The lower courts had split. Circuit disagreements had piled up. The conditions for a sweeping, definitive ruling were perfectly ripe. Nobody, however, predicted what came next. Early this term, constitutional watchers detected what they described as an extraordinary convergence of jurisprudential momentum, including a pattern of originalist reasoning that had not been applied this broadly in over 50 years. These are the kinds of legal frameworks that the Supreme Court only deploys when it is signaling something very specific: a fundamental reinterpretation of existing precedent, a direct rebuke to lower court overreach, or a generational reset of how a constitutional right is understood. Observers didn't know which category this ruling would fall into, or whether it would fall into all 3 at once. But what they did know was that the court was changing its posture on the Second Amendment's practical application. And when the Supreme Court shifts its interpretive posture, even slightly, every prosecutor, every defense attorney, and every law enforcement agency in the country pays attention. The case centered on a deceptively simple question: when a licensed gun owner has a firearm legally stored in their vehicle, under what circumstances can that firearm be used as justification for search, seizure, or arrest? The answer the court gave was not simple at all. It was unanimous. It was sweeping. And it is now the law of the land. The ruling issued by the Supreme Court today was not incremental. It was not narrow. It was not symbolic. It was transformative. Legal expert after legal expert described the court's decision as expansive, historically grounded. And perhaps most importantly, operationally immediate, meaning law enforcement agencies must begin adjusting their protocols today, not after a legislative grace period, but sweeping legal change only reshapes behavior if the institutions affected respond. Law enforcement agencies across the country did not hesitate. In fact, within hours of the ruling's release, police departments in at least a dozen major cities had already issued internal guidance memos to their officers. Here's what we know. Within hours of the ruling dropping, the Department of Justice initiated a formal review of existing stop and search guidelines as they relate to firearms in vehicles. These weren't routine policy reminders. These were emergency legal compliance directives, internal orders that agencies only issue when a court decision fundamentally alters the rules of engagement on the street. Tonight, sources confirmed that the Supreme Court ruled in favor of the petitioner, a licensed gun owner who had been stopped, searched, and charged after an officer observed a legally owned, properly stored firearm during a routine traffic stop. The court held that the mere presence of a legally owned firearm in a vehicle does not constitute probable cause for a search, does not justify an extended detention, and cannot be treated as inherently suspicious behavior under the Fourth Amendment. The ruling struck down precedent in 3 specific circuits. It overturned lower court logic that had allowed officers to use firearm visibility alone as a trigger for escalated stops. It invalidated policies that had permitted brief detention for firearm verification beyond the scope of the original traffic stop. It rejected the argument that a legal firearm in a vehicle creates a presumption of danger sufficient to override a citizen's constitutional rights. In other words, the court targeted the legal architecture that had allowed routine stops to become extended searches, the framework that would have made those searches defensible in court. This is what made the ruling so significant. The lower court's reasoning wasn't just philosophically flawed, it was operationally dangerous. It represented the kind of interpretive drift that could strip millions of law-abiding gun owners of their Fourth and Second Amendment rights simultaneously if left unchecked. And the Supreme Court, understanding that fully, responded with legal force, not recklessly, not impulsively, but with a 9-0 decision that leaves no room for reinterpretation. They didn't split the difference. They didn't defer to legislative resolution. They drew a hard constitutional line and held it with every justice's name behind it. And here's where the story becomes even more consequential. Legal historians now believe the court's ruling was designed to test and correct the durability of Second Amendment protections in everyday civilian life, following years of erosion through lower court decisions made in the name of public safety. The lower courts wanted to see whether the Supreme Court would allow practical policing concerns to slowly hollow out constitutional rights. But instead, the opposite happened. The court didn't defer to law enforcement convenience. It reasserted constitutional supremacy in language so plain, so unanimous, that even the most aggressive prosecutors took notice. You don't get a 9-0 ruling easily. But today, the petitioner, and by extension, every lawful gun owner in America, did. Constitutional scholars speaking with major publications under anonymity describe the court's approach as originalist anchoring, a way to prevent future courts from drifting away from the text's original protections under the pressure of public safety narratives. The ruling proved that the Second Amendment remains both legally robust and practically enforceable. The court's reasoning was not only historically grounded, it was written so precisely that lower courts will find it nearly impossible to distinguish around. That precision matters because it shows the court is not reacting to political pressure. It is proactively insulating constitutional rights from gradual erosion. As reactions continued pouring in throughout the day, we learned more about the scale of this ruling's impact. The NRA and gun owners of America called it the most significant Second Amendment victory since Bruin in 2022, forcing a full reassessment of stop and search training nationwide. Civil liberties organizations, including the ACLU, issued statements supporting the ruling's Fourth Amendment implications, marking a rare moment of cross-ideological alignment. Prosecutors in states with strict gun laws acknowledged the ruling would require legislative adjustments to maintain current enforcement frameworks. This wasn't just a win for gun owners. This wasn't just a procedural correction. This was a structural realignment of the relationship between law enforcement discretion and constitutional rights. This was a reaffirmation of equal protection, the principle that a right exercised legally cannot be treated as inherently suspect, and equal, consistent constitutional protection is the one thing incremental legal erosion has struggled to maintain since the post-Heller era began. Remember, critics of expanded Second Amendment protections thought the court would never rule this broadly. They thought public safety arguments would provide enough cover for continued lower court latitude. They thought the political atmosphere would push even conservative justices toward a narrower, more deferential decision. But tonight, the exact opposite happened. The court went unanimous, a statement that transcends ideology. The ruling was written in plain, direct language designed to be applied uniformly, not parsed selectively. And it was released with a clarity of purpose that signals this court intends to hold this line. What makes this moment so legally significant and so politically charged is that the ruling arrived at a time when gun policy remains one of the most volatile fault lines in American public life. Gun control advocates want stricter enforcement frameworks. Law enforcement unions want preserved discretionary authority during stops. Second Amendment groups want constitutional rights protected without exception. Civil libertarians want Fourth Amendment protections applied equally regardless of firearm status. The court is now the fixed point around which all of these competing demands must rotate. And when courts in that position issue unanimous rulings, they're not doing it from political calculation, they're doing it from constitutional obligation, they're doing it from the text. The Department of Justice's review, now formally initiated and distributed to U.S. attorneys nationwide, was designed to signal that the federal government is not willing to allow enforcement practices to continue in conflict with the new constitutional standard. Officials said plainly that prior stop and search justifications based solely on firearm presence were inconsistent with the court's constitutional framework. That is careful bureaucratic language for what we were doing before is no longer legally defensible, and we need to change it immediately. You don't usually hear that kind of rapid institutional acknowledgement unless the ruling is airtight. This one is. Meanwhile, the majority opinion itself, written with uncommon directness, addressed the American public as much as it addressed the lower courts. The court wrote, "The Second Amendment is not a second-class right." The court wrote, "A citizen who exercises a constitutional right lawfully cannot be treated as a suspect for that exercise alone." And the court wrote, "Law enforcement discretion, however valuable, cannot serve as a mechanism for the erosion of rights the Constitution expressly guarantees." These are not rhetorical flourishes. These are binding instructions from an institution that understands and is now demanding that constitutional rights mean what they say. Here's what makes the situation even more far-reaching. This ruling wasn't isolated to vehicle stops. Along with the primary holding, concurring opinions signaled skepticism toward red flag enforcement mechanisms that lack individualized probable cause. The Fourth Amendment reasoning suggests future challenges to pretextual stops in high gun density areas may now have stronger legal footing. State legislatures in California, New York, and Illinois have already been put on notice that certain storage and transportation laws may face immediate constitutional challenge. All of this emerged from a single ruling on a single day. When the Supreme Court moves multiple constitutional pieces at once, it means something larger is underway. Legal analysts are now considering several possibilities. One is that this ruling is the foundation for a broader Second Amendment enforcement project, a multi-case effort to restore the right's full practical application. Another is that the court is attempting to preemptively seal constitutional protections before a future legislative or regulatory push attempts to narrow them. A third possibility, the one animating the most urgent policy conversations tonight, is that the court is attempting to establish a constitutional floor so clearly defined that no future administration can erode it through regulatory action alone. Today, the court took ambiguity off the table. They didn't issue a narrow holding. They didn't leave room for circuit-by-circuit variation. They didn't invite further lower court experimentation. They ruled unanimously, and that unanimity is the message. What we're watching now is a test of constitutional durability. The court wants to see whether its rulings will be implemented with fidelity at every level of the justice system. Law enforcement agencies want to show they can adapt professionally and constitutionally. Legislatures want to prevent legal chaos in jurisdictions with restrictive gun frameworks. And citizens, gun owners and non-gun owners alike, want to know whether constitutional rights are real or merely theoretical. Tonight, we've heard from legal organizations who are now mobilizing to file follow-on challenges in circuits where related enforcement practices remain in effect. They say this ruling creates immediate grounds for appeal in hundreds of pending cases. They say prosecutions based on the now invalidated stop and search framework are legally vulnerable. And they say the court's decision to rule 9-0 is likely part of a broader judicial strategy intended to place Second and Fourth Amendment protections beyond the reach of incremental political erosion. The Constitution is not retreating. In fact, it is advancing. Today's ruling, unanimous, clear, and historically grounded, sent a message to lower courts that the drift ends here. And it sent a message to every American that the Supreme Court still considers the Bill of Rights non-negotiable. As the days ahead unfold, we expect more details to emerge about how agencies, prosecutors, and legislatures will respond to the new constitutional standard. But what we do know is that the Supreme Court's decision was timely. It arrested a pattern of incremental rights erosion before it became irreversible. It gave law-abiding gun owners a clear and enforceable legal shield. And it reminded every institution in the American legal system that constitutional rights are not subject to administrative convenience. What happens next will depend on how seriously every level of government treats this ruling. If they implement it faithfully, this moment will be remembered as the day the Second Amendment was made whole again. If they resist, the court has already shown it is unified, prepared, and resolved. They have shown they are ready to hold the line. And tonight, for the first time in years, the opponents of broad Second Amendment protection appear to be recalibrating. The policy space is quiet. Too quiet. And when that side of the debate goes quiet after a Supreme Court ruling, it means they are regrouping. It means they are choosing their next move carefully. Because tonight, those who believed public safety arguments could slowly displace constitutional rights learned something they should have known all along. The Constitution does not negotiate. A unanimous court does not leave room for workarounds. And 9 justices speaking with one voice is a message no lower court, no legislature, and no administration can afford to ignore. This story is far from over. But tonight, one thing is clear. The Second Amendment is still standing. The Fourth Amendment is still standing. And as of today, both of them are standing stronger than they have in a generation. We will be here watching every development as the legal and political response to this historic ruling continues to unfold.